Hello everyone, welcome to Apurva's Legal Bites. Today's topic is on summons cases and warrant cases. They have been defined under Section 2, Clause W and Section 2, Clause X of Code of Criminal Procedure. Now coming to the definitions. Warrant case. It is a case relating to an offence punishable with death penalty, life imprisonment and imprisonment for a term exceeding 2 years. Whereas summons case, it is a case relating to an offence and not being a warrant case. Means all cases other than warrant cases are summons cases. And here the punishment is up to 2 years only. Means it may be 1 month, 6 months, 1 year, 2 years, etc. Okay. Now, there are two procedures for the trial of warrant cases. That is, cases instituted on a police report and the cases instituted otherwise than on a police report. And this trial process is contained in Chapter 19 from sections 238 to 250. Whereas there is only one procedure for the trial of summons cases, whether it is instituted on a police report or on a complaint. And this trial process is contained in Chapter 20 from sections 251 to 259. Okay, and these procedures are completely different in several aspects. So now let us see what are the differences between the summons case and a warrant case. So first, summons cases are less serious and the procedure is simple and speedy, whereas warrant cases are very grave and the procedure is a bit slow and complicated. The summons cases are triable by magistrates and or judicial magistrate of first class, whereas warrant cases are classified into more serious and less serious. So more serious are triable by court of session and less serious are triable by judicial magistrate of first class. Now coming to the nature, the summons cases are bailable and non-cognizable, whereas warrant cases are cognizable and non-bailable. And remember, the petty cases come within the purview of summons cases, not warrant cases. Okay. Now, in summons cases, the court conducts either summary trial or summons trial, whereas in warrant cases, the court conducts either sessions trial or warrant trial, which may be either on police report or a private complaint. And in summons cases, there is no question of written charge. The court explains the charge orally to the accused person, whereas in warrant cases, the charge must be in a written form and the court explains the same to the accused person. Now coming to section 204. Actually it is related to summons cases and warrant cases. So now let us see what does this section 204 tells about. Here you need to remember 4 important points. First, in summons cases, summons shall be issued for the attendance of an accused person, whereas in warrant cases, summons or warrant may be issued. It is left to the discretion of the court. Second, no summons or warrant shall be issued against the accused person until a list of prosecution witnesses has been filed. Third, when the proceedings are instituted on a written complaint, then the summons or the warrant so issued must be accompanied by a copy of that complaint. Fourth one, when any law prescribes for the payment of process fee or any other fee, no process shall be issued until such fees are paid. And if such fees are not paid within a reasonable time, then the magistrate may dismiss the complaint. Okay, now again coming back to the differences. In summons cases, the accused may be acquitted when the complainant does not appear and on the death of the complainant. Whereas in warrant cases, the accused may be discharged when the complainant is absent. And in both summons cases and warrant cases, when the accused pleads guilty, the magistrate will record his plea and may in its discretion convict the accused on such plea. And summons cases give lesser opportunity for the defense, whereas warrant cases give greater opportunity for the defense. And in summons cases, the accused has one opportunity to cross-examine the prosecution witnesses, whereas in warrant cases, the accused has 2 opportunities to cross-examine the prosecution witness. One is before the charge and another is after the charge. And here the last important point is a warrant case cannot be converted into a summons case in the course of a trial, but a summons case can be converted into a warrant case, and this is provided under section 259 of Crpc. It tells that the course of the trial of a summons case relating to an offence punishable with imprisonment for a term exceeding 6 months, and if the magistrate is of the opinion that in the interest of justice the offence should be tried according to the procedure prescribed for the warrant case, then the magistrate may rehear the case from the beginning and may also recall the witnesses who have already been examined. Okay, so this is the end of the topic. So to know the law in a simplified way, don't forget to subscribe to my channel Apurva's Legal Bites.